Hey everybody, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and we recently did the first part of a two-part webinar series on how should your credit reports read after a Chapter 7 bankruptcy discharge. And this is a recent case that came out against Experian that has a pretty detailed discussion of sort of what Experian is doing or what they're supposed to do when they get an account to see should this be listed as discharged or included in bankruptcy with a zero balance. So if you're interested in how credit bureaus are supposed to report discharged debt, then I think you'll find this interesting. And we'll at the end see the date of this. It's actually this month, March of 22. So what happens is both parties file cross motions for summary judgment. So the plaintiff says, hey, I'm entitled to summary judgment. So we don't even need a trial, just enter judgment in my favor. And Experian says, throw the case out, enter judgment against the plaintiff, the consumer, because there's no way a reasonable jury could ever believe or find for the plaintiff. So here are the background facts. So we see Experian operates as a CRA, credit reporting agency, sometimes called a consumer reporting agency, credit bureau, all the same thing. So it obtains credit information from creditors, those are called furnishers, and then it puts those into reports. Now, what if a debt is discharged through Chapter 7 bankruptcy? Well, then Experian will update those accounts to report the debt is discharged in bankruptcy with a $0 balance. Well, why do they do that? Because bankruptcy shields the individual debtor from collection actions for discharged debts. And then LexisNexis, which is a public records vendor, and yes, they are also at times a credit bureau, but for our purposes, they are just simply a vendor. They work for Experian. So they report to Experian when a consumer petitions or files for bankruptcy and when the bankruptcy court enters the discharge order. Now, the discharge order is simply an order that says, hey, the debts that you filed bankruptcy on, with certain exceptions, are discharged or wiped out. That creditor, that collector, whoever it may be, can never attempt to collect that debt against you because you do not owe it. That's why it has to show up on your credit report as a zero balance. So continuing on, the court says most but not all debts incurred before the bankruptcy filing are discharged through bankruptcy. So Experian presumptively, let me say that again, presumptively marks some debts as discharged, well, what? If they meet certain qualifications. Now, so think about it this way. Experian is notified by LexisNexis. So that's one way they find out. Now, creditors or furnishers, data furnishers, can notify Experian about accounts that have been discharged. And consumers can say, hey, this is a debt that's been discharged. So there's multiple ways Experian can find out. It can be through LexisNexis, through the data furnisher, through the consumer. Now, what's important is something that happened way back in 2008, so 14 years ago. So Experian was involved in a lawsuit in California called the White case, and it settled that, and it set forth certain conditions and requirements on Experian about how they would have to treat discharged debt. And we're going to get into some of the detail here, and if you're interested, we can pull up that order from back in 2008 and go through it, because in a lot of ways that order is still in effect. All right, so what does White say? Well, within 60 days of notification of discharge, CRA, so those are the credit bureaus, must identify presumptively discharged collection accounts. The reason they're saying collection accounts here is this is a collection account that this lawsuit that we're reading the order on is about. Okay, and indicate that those accounts were included in bankruptcy and have no outstanding balance. So this is what's known as the bankruptcy scrub. Now, if a creditor reports a collection account after the initial scrub, the CRA must run an additional scrub to determine whether the new account is discharged. So when the Bureau knows that somebody has filed bankruptcy because LexisNexis tells them, then they say, okay, well, let me examine all the accounts to see which ones I should mark as being discharged. But what if you get an account after that initial scrub? So 3 months, 6 months, 9 months later, after the discharge, you get an account. Well, then you have to run another scrub to see should that account be marked as discharged. So the white order does not specify when the second scrub, sometimes this is called a look back scrub. The reason it's look back is we've gone forward in time, let's say 6 months after the discharge, and then a creditor pops up, a furnisher pops up and says, hey, I want to report this. Well, we've got to look back in time at the bankruptcy and the discharge to see, okay, should that account have been marked as included in bankruptcy? So Experian implements its bankruptcy scrub. So that's going to be that initial scrub within 8 days of receipt of the discharge order. So let's kind of think of a timeline here. I filed bankruptcy January of 21. Well, until there's a discharge order, none of my debts are discharged. But then I get the discharge order in March of 21. And then Experian is notified of that usually very quickly. Typically, they get this information on a daily basis from LexisNexis. And so, and by the way, there's nothing with opting out with LexisNexis. That has no impact on LexisNexis as a vendor, just simply looking up the court records and reporting that to Experian. So Experian finds out, let's say March 15. Well, then within 8 days, they have to run that initial scrub. Now, here's where there's a little bit of a dispute. Experian contends in the consumer disputes that Experian also updates collection accounts with a date open within 18 months of the bankruptcy filing. So let me stop here for a moment. And sometimes in this opinion, I think there's a little bit of just calling everything a collection account because that's what the subject of this lawsuit's about. But if it's a real collection account, it will have a date open. That's not the date that the debt was open. That's the date that the collector opened the account. So I might have an account with Discover Card that opened in 1994, but then I default on it and it goes to a collector and they get it today. Well, as I'm recording this is March 26, 2022. So the collector would put an open date of March 26, 2022. Okay. But the debt was incurred before that. So what Experian is saying is, well, look, if you have a date open within 18 months of when the bankruptcy was filed, we're going to assume that that was actually the debt was incurred before the bankruptcy and therefore should be marked as discharge. So then going back to the opinion, Experian runs its look back scrub every other month for an 18-month period. So they don't do it every day or every week or even every month. They do it every 60 days, we could say. All right, so now let's look at the actual facts here. So and some of these dates will be important, and so I'll try to stress these. We've got June of 2019, consumer files for bankruptcy. At that time, she was delinquent on a utility company, but she did not list that debt on her petition. Now, sometimes that can be a big problem. Usually it's not a big problem because most bankruptcies, even if you don't list a debt unless you intentionally hit it, it will still be considered discharged. Okay, now it does vary based on where you are, but that's not an issue in this case right now. So now we have September. We have this Midwest Receivable Solutions, a collection agency, gets the debt. So they open the account. 2 weeks later, so that would be in October, consumer received her bankruptcy discharge. So let's think about this. The debt was before the bankruptcy was filed. So sometimes we call that a pre-petition. So it's before the petition, before the bankruptcy filing. And then while the bankruptcy was pending, the collection agency got the account. And then shortly after that, the discharge happened. So LexisNexis notified Experian of the discharge 1 day later, which is pretty typical, and Experian conducted its initial scrub shortly thereafter. Well, it did not see Midwest because Midwest was not reporting on her credit report, so it would not have seen it. So 4 months later, the collector reported the account to Experian for the first time with an open date of September. Now, why does it have an open date of September? Because that's when the collector got the account, was in September. So that's what the open date for a collector means. And the initial delinquency date of June. Well, why does it show that? Because that's when she became delinquent. So remember, if we go back to the top of this paragraph, June 2019 filed for bankruptcy. At the time, she was delinquent on a debt owed to the utility company. So Midwest did not report the debt had been discharged. Now, they had not been notified that it had been discharged, so that kind of makes sense. All right, let's go to the next page here. So Experian listed the account with 370 past due. It did not say it had been discharged, or it did not show a $0 balance. It actually have to definitely show the discharge and either show a $0 or some bureaus will show a blank, but it cannot have a $370, for example. Now, in February of the next year, so remember our dates, we filed bankruptcy in June. At the time we owe the utility. In September, the collector gets the debt. And then in September after that, or maybe it was slightly in October, we then get our discharge. And now in, let's back up and see when they reported it. So it says 4 months later, they reported it. Okay. So now in February, she pulls her credit report. It shows the outstanding debt, but she does not dispute it with Experian. Okay. So it stayed on her Experian report for about 5 weeks. Well, what happened? Well, in March, Experian received notice of a credit dispute from TransUnion and updated the account. So what happened is TransUnion was involved with the dispute, and Experian was notified about this. And so it deletes the account. Now, Experian says, but the consumer disputes, that if the account had remained on her file, then in April, remember they do that look back where they're looking back in time to see, okay, do you have anything with an 18-month open date from the time of the bankruptcy petition? They do that every other month. Well, April happened to be their month. And so, well, look, when we would have done an April look back, we would have seen the open date, September 19. That was within 18 months of the bankruptcy filing. Remember, the bankruptcy filing was June 2019, so this would clearly be within 18 months. So they say, well, we would have, taken care of it then. And so during the period, Experian listed the account. There were 7 hard inquiries. There was 1 capital one. We'll come back to that. All right, so what's the legal standard? We talk about this thing, summary judgment. What does that mean? Whoever moves for summary judgment, and remember, in this case, both parties moved for summary judgment. They have to show there's no genuine dispute as to any material fact. Okay? Well, what's a material fact? It's something that's important that would make a difference. And the movant, the one who filed for summary judgment, is entitled to judgment as a matter of law. So a genuine dispute as to any material fact exists if the evidence is such that a reasonable jury could return a verdict for the other party. And then when determining whether a genuine dispute exists, must view the evidence and draw all reasonable inferences in favor of the non-moving party. So if you and I are in a lawsuit and I file summary judgment against you, and the judge is like, well, you could kind of look at this piece of evidence in different ways, the judge has to lean in your favor as the non-moving party. All right, so let's look here at the discussion of the Fair Credit Reporting Act. So the FCRA provides relief to consumers if a credit bureau reports inaccurate information, but it is not a strict liability statute. Typically, the FDCPA, Fair Debt Collection Practices Act, dealing with debt collectors, is a strict liability. We just say, did you get it wrong? If you got it wrong, boom, you violated the law. That's not the case with the FCRA. It has to be something that is negligent or willful. So the court points out, given the volume of data credit bureaus must produce and the complexity of their reporting systems, mistakes understandably occur. So what's the rule? They must follow reasonable procedures to assure maximum possible accuracy of the information. And unless it's beyond question, the reasonableness of their procedures, remember, their procedures are the reasonable procedures to assure maximum possible accuracy. The reasonableness of those procedures is a question for trial, which that's another way of saying this is a question of fact that the jury would have to decide either yes, this was reasonable, or no, this was not reasonable. So now the court says, well, let's look at the reasonableness. So here's what the consumer argues. Experian failed to implement reasonable procedures to prevent the inaccurate reporting of that collection account. Now, Experian responds that we were absolutely reasonable, and you don't need a jury to look at this. 3 reasons. It reasonably relied on the collection agency's reporting. And remember, the collection agency did not tell Experian that this was a discharged debt. And number 2, it complied with that white order. Remember, that's the order from California back in the mid 2000s here, like what was it, 2006 or 8. And so because we complied with that, we are absolutely insulated from liability. You can never say that we were unreasonable. And then number 3, they say, hey, this is this really complicated legal issue. I mean, how could we possibly determine whether or not something is discharged in bankruptcy, not discharged? You can't expect us to do that. Well, the court says, sort of gives us the conclusion here, it's not beyond question. So I'm not going to grant summary judgment to either party. And it says Midwest failure, that's the collection agency's failure to report the account as discharged, does not shield Experian from liability. So it generally relies on creditors to accurately report. Midwest, the collector, failed to do so, but Experian was on notice that the consumer completed the bankruptcy process. And it is clearly familiar with the straightforward impact of a Chapter 7 bankruptcy. In other words, Experian, you know what a Chapter 7 bankruptcy does. You report these things on people's credit reports. You can read the order. You can understand what happened. Now, Experian says it was reasonable to not assume the account was discharged. Well, why would that be reasonable, to assume it was not discharged? They say because there are several exceptions. So think about what Experian is saying. They're going, look, it's remotely possible that a debt that was incurred before bankruptcy might not be discharged. So, hey, we should therefore assume that it was not discharged. And the court says, no. It says, Experian's bankruptcy scrub procedures illustrate that it is not unreasonably burdensome for Experian to parse these limited exceptions, particularly where creditors code the types of accounts that bankruptcy exempts. So what they're talking about here is you can look at an account, and this is done under the Metro 2 format. Is this a collection account? Is this an auto loan, a credit card, a student loan? What is this? And so you know, as a credit bureau, if this is an auto loan, a collection, a medical bill, credit card debt, personal loan, that's not going to be exempted, okay? And so we're not talking about, for example, a student loan that might typically not be discharged. Okay, and then it says the discharge order put Experian on notice that her accounts may be affected by her bankruptcy, and so they should have done more digging here. And then the court rejects Experian's arguments that updating discharged accounts requires a legal determination they're not obligated to make. So this is a huge issue. The credit bureaus want to say every single dispute is a legal issue. And hey, we're not the judge. We don't wear the black robes. We can't figure this stuff out. I mean, it's so silly that I've even seen the credit bureaus make this argument. Look, you sued us saying that we messed up. You sued the furnisher saying the furnisher messed up. We all deny we messed up. See, that's a legal issue a judge has to decide, which, in other words, they're saying we can never be sued under the Fair Credit Reporting Act. It's a really silly, outrageous argument that doesn't help them in the long run. It actually makes them look very silly. So the court says, well, you're not obligated to come to legal conclusions. Taking notice of a previously resolved legal dispute involves some knowledge of the legal impact of court decisions. Does not require a credit bureau to make any legal determination. So they're saying, look, we're not asking you, Experian, to wear the black robes. Somebody else already wore the black robes. The bankruptcy judge wore the black robes. You just have to look at their order and follow it. You don't have to make the order in the first place. This is not a case where Experian need resolve complex legal issues. They can reasonably apply Chapter 7 bankruptcy discharge order to a consumer's credit file as evidenced by the comprehensive white order. That's that case from California, like 14 years ago, under which Experian admits it should have assumed the bankruptcy discharged the Midwest account. So then Experian contends that its compliance with the white order renders its procedures presumptively reasonable. I mean, so you can't even look at us. Hey, we followed white, so no need to look any further. It says its look-back scrub adheres to part of the white order by updating collection accounts with the date open within 18 months of its bankruptcy filing date. And so that would have picked it up in April, and it would have deleted it. It says the court need not resolve Laura's objection to Experian's factual support, which she argues comes solely from a post-deposition reach-back affidavit. Okay, so let me stop there and explain that. Here's what happened. The plaintiff's lawyer, the consumer's lawyer, took a deposition of Experian. Well, Experian's a corporation, so it can't talk, right? So who do we talk to? When we depose, we take a deposition of a corporation. Well, the corporation has to designate what's called a corporate representative. This is a human being to speak on behalf of the company. And so Experian did that. And the consumer's lawyer asked some really good questions. And Experian gave some, what I believe are truthful answers. And then they realized, oh man, those truthful answers are going to hurt us. And so then they come back with an affidavit that says, oh, basically, I just got a bunch of things wrong in my deposition. Now here's the truth. Don't believe me back then, believe me now. So that's why the consumer's lawyer is calling this a post-deposition. So post meaning after. So after deposition, and it's an affidavit, a sworn statement. They call it a reach back because it's trying to reach backwards in time and say, oh, wait, let me go back to my testimony, 4 months ago and fix it and change it, because it makes us look really, really bad. And the court says, well, even if I believe that affidavit, a question still remains whether it's reasonable to run the look-back scrub every 60 days, as opposed to whenever you receive a new collection account with an initial delinquency date prior to the bankruptcy. So remember, the bankruptcy was filed in June. The delinquency happened in June before the filing of the petition. So the court's saying, well, look, I think a jury's going to have to decide if it's okay for you to wait 60 days after you get an account, because they could have run the every other month scrub, say yesterday, and then today they get the account. Well, they're not going to run it for another, 59 days. And the court's saying, I think a jury has to decide maybe whenever you get an account, when the delinquency date shows prior to the bankruptcy filing, then you should run a scrub. So let's talk for a moment about this delinquency date. Every furnisher who reports to a credit bureau has to give the date of first delinquency. Well, what does that mean? Kind of what it sounds like. It's the date that you first went delinquent and then never recovered from that. Now, Equifax will report this on the reports. Experian and TransUnion refuse to do so. So they have the data because a furnisher is not allowed to report this without having that date. And this is the date that determines when the account will fall off of your credit report. But for purposes of a bankruptcy discharge, the court's saying, I think a jury has to decide if you, a credit bureau, get an account and it shows the date of first delinquency is before the petition date of the bankruptcy filing. And remember, the public record part of your credit report will show, here's your bankruptcy, here's the case number, where it was filed, the date it was filed. So that's why that date is important and why the date of first delinquency is important. So this is a really, really important case for those of us who file lawsuits under Fair Credit Reporting Act, because there are a lot of errors with bankruptcy. So folks have gone through bankruptcy, they get their discharge, and they don't get their fresh start because accounts which were discharged are still reporting as owing, when that is absolutely not true. Now, the rest of this is about damages. We'll go through this kind of quickly. Some of this is going to sort of turn on where you are in the country. So she bears a burden that she is entitled to damages. There has to be a relationship between the violation of the Fair Credit Reporting Act and the damage. So two types of damages. Pecuniary harm, that's economic. So that could be like you were denied credit, you lost a job, you lost your security clearance. And non-pecuniary, which is more of emotional distress. And the court says she did not meet her burden for emotional distress. In the Seventh Circuit, where this case is pending, there's a strict standard for finding of emotional damage. I'll just tell you, where I practice in the 11th Circuit, there is not a strict standard. It's just normal rules of proof that you have to prove it, but there's no heightened standard for it. But some courts do say that they impose a heightened standard. And so it's just these conclusions about frustration and only her own testimony. It's always good when you can have somebody else testify that they observed you being upset about something that happened here. And she mentioned her credit issues to her psychiatrist, but that does not fix it, as she did not seek psychological treatment for the emotional distress. Now, I don't know what the standard is in the Seventh Circuit. Again, in the courts where I practice, we don't have to have a doctor or a psychologist, psychiatrist, counselor. Now, it's good if you have that, but you don't have to have that. I don't know if that's a requirement in the Seventh Circuit, or if the judge is simply saying, you might have mentioned you had some credit issues, but you did not mention that it was Experian reporting this account is what bothered you. Let's see. And so the parties argued a lot about this in the briefing leading up to this, so we won't get into all this. And then to get statutory damages, you have to show that it was willful. It'd be the same thing with punitive damages. And it's willful if the company acted in reckless disregard of the law's requirements by running a risk of violating the law substantially greater than the risk associated with a reading that was merely careless. And this says the consumer did not offer evidence to support that. And says Experian knew it maintained inaccurate, unreasonable procedures, later forced to update its procedures, but there's no evidence of that. So the court throws that out. And then the consumer says, well, I was denied an auto loan from Capital One because of your reporting. And the judge says at the conclusion, look, I'm going to give her the benefit of the doubt on this. It says, although it's weak, the evidence is sufficient to survive summary judgment to the Capital One. And so grants in part, denies in part, Experian's motion, and completely denies a plaintiff's motion for summary judgment. And you can see this just happened March 18, 2022. So hope you found this helpful. If you are interested in this sort of stuff, we had part 1 2 days ago on Thursday, March 24th, of our webinar series on what are the common violations we see after a Chapter 7 discharge. Now, next Thursday, that'd be the 31st, we'll go through actual examples of credit reports and look and see, okay, do we see violations here? And there'll be a sign-up link to that. It's just our weekly webinar, and we do different topics every week. And so hope you found this helpful. And if you have any questions, just reach out to me or put a comment. And you guys have a great Saturday or whenever you happen to be watching this. Okay, talk to you soon. Bye-bye.